not created until 2004, which was 4 years after State versus Jones, in which the North Carolina State Supreme Court determined that North Carolina assault convictions can be committed with culpable negligence. Under that formulation, the legislature clearly intended the statute to apply broadly. And because an APIS offense can be committed with culpable negligence, it is not a crime of violence, as this court has recognized in Simmons and as the Supreme Court recently recognized in Borden. This court should remand, should find that an APIS offense is not.
What crime do you say can be committed with culpable negligence?
The assault by injury, assault inflicting physical injury by strangulation, Your Honor. The APIS offense is the offense that we are determining can be committed with culpable negligence. As State v. Jones, the North Carolina Supreme Court stated in State v. Jones that culpable negligence is an element, that assault can be met with the culpable negligence mens rea. The APIS offense.
So I don't have any difficulty with what you're saying when you say assault can be committed with culpable negligence. But of course, now we're dealing with the whole statute, which is assaults another person and inflicts physical injury by strangulation. And under our Vincent decision and some others, you have to look at all the elements of the statute. If we looked at just assault, we'd be looking at one element, and I would agree with you, but I think we're required by our precedent to look at the statute, every little bit of it.
I agree, Your Honor, and I don't disagree that the APIS offense has this additional definition of the method of strangulation, of the method of the assault being completed.
And that's an element, is it not?
It is, Your Honor, and the way that the North Carolina jury instructions have defined that element is that the defendant assaulted the victim by intentionally and without justification or excuse, and then it says strangled the victim. As this court analyzed that particular instruction, it's identical in its formulation to the instruction in Simmons and to the instruction in Vincent. The only difference is that here we happen to have by strangulation, whereas in Vincent or Simmons, it was a different method to accomplish the assault.
Isn't that important? I mean, doesn't by strangulation inform the elements? I mean, if we give that some meaning, we have to, decide whether that can be, conceivably committed without intent. And I've read the briefs and talked about the kind of hypotheticals, and those are pretty out there, and there's no cases, and I realize cases aren't determinative, but yeah, I'm just trying to figure out how we can give any real significance to by strangulation and then consider that it can be committed negligently or recklessly.
Your Honor, I think an analogy here would be to Simmons, where the assault can be committed by use of a deadly weapon. That is an intentional act, but it can also be committed with culpable negligence.
Simmons, the vehicular case?
Simmons was a vehicular case, and they determined it was
pretty easy to contemplate someone can negligently or recklessly operate a vehicle. Those things happen with some degree of frequency. That you have strangulation in a way that's not intentional. I can't even imagine it, and certainly can't imagine it being prosecuted. And the fact that there's no cases seems to at least be somewhat relevant to that.
Your Honor, I think I have a couple of responses to that. First, I would go back to note that this is a relatively new statute, and so the fact that it is not in front of the North Carolina Supreme Court yet in a published opinion, really not.
But I want to get back to the follow up on Judge Quattlebaum's. How does one strangulate someone and inflict a physical injury on someone? How does one do that negligently? I mean, the whole idea of negligent strangulation inflicting physical injury seems to me a contradiction in terms.
Your Honor, I would respectfully disagree with that. I think that we cited in our reply brief State v. O'Carroll, which was a New Jersey case in which the court noted—
New Jersey case?
It was a New Jersey, yes, Your Honor. It was a New Jersey state case, excuse me, in which the judges noted that in many of their strangulation cases that had been charged that way, I think approximately like 40% had come back as reckless actions.
Okay, now let me ask you that. What about North Carolina? Because the government brought forward 23 North Carolina cases addressing assault by strangulation, and all of those 23 cases involved knowing or purposeful strangulation, and they were submitted to the jury on that basis.
Your Honor, I think that's true, and I think that is the same reasoning that the government did in Simmons and in Vinson, that presenting a mountain of cases does not resolve this reasonable probability question. And I would note that under Borden, for example,
excuse me, but why doesn't it resolve that question? Because in the Battle case, we said that you can't just talk about what theoretically is possible. You have to show actual prosecution of the relevant offense in cases in the manner that you claim. Now, this is practical, and when one side says here are 23 cases and they've all involved assault by strangulation and they were all submitted to the jury under a knowing or purposeful strangulation standard, none involved negligent strangulation. How do we get around that?
Your Honor, I think that we go back to the Supreme Court's recent case in Borden, in which the government in Borden made the same position, made the same argument that it's making here, that the state court had repeatedly only upheld convictions of intentional conduct, of knowingly violent conduct. And the court in Borden confirmed that under the categorical approach, the existence of such cases is neither—
Yes, but what I'm discussing with you, I mean, of course, I quite agree with Borden, and if I didn't, it still wouldn't make any difference. But I realize that Borden required purposeful or knowing mens rea, and that is exactly under Borden how the case was. How all of these 23 cases were submitted to the jury. They were submitted on knowing or purposeful strangulation, which conforms with Borden.
Your Honor, I again respectfully disagree. In Borden, one of the reasons that the court held that reckless conduct doesn't fall within the elements clause is because the court in Borden gave examples of cases that seem that might defy common sense, which I think is what the court is struggling with here. That Borden, for example, gave the example of a dad taking his daughter go-karting and forgot to strap her in, and when the child was injured, he was charged with reckless assault. There are mechanisms in which the cases can be understood that way, and I think we provided some of those examples in our briefing. In the North Carolina Supreme Court, for example, there was State v. White, where a child ended up swallowing plastic, and the court noted that he strangled to death on the plastic. And they ended up finding that it could have been a reckless homicide because the mother knew the child liked to eat the plastic, and had that.
But I'm talking about this particular statute, and so you start with the idea that negligent strangulation, which inflicts physical injury, that doesn't seem to me something that can be done negligently. And then when you get down to what is actually being charged under this statute, not under this analogous situation or that under analogous situation, but under this statute, both the North Carolina jury instructions and the North Carolina cases talk about intentionality.
Well, Your Honor, the cases and the instructions, for example, do talk about intention, because North Carolina assaults do have to be intentional, but they can be committed with culpable negligence. Because the case law was formed under the common law, the statute itself doesn't speak to any sort of intent unless the legislature wants it to. So in Townsend, for example, the court did in fact add a specific mens rea element, which was specific intent to kill. And if
in the jury instructions, didn't intentionally modify strangulation, not assaulted, it modified strangulation, didn't it?
But that is the case as well for Simmons and for Vinson. The instruction is identical. And I know that we are caught up here in the semantics, but I think that the way that the legislature drafted the statute here is that the intent element can be met with culpable negligence. If this court looks at North Carolina's other assault statutes, North Carolina doesn't have a general felony assault statute. And so each of the assaults are very specific acts. So for example, there's a malicious castration, which includes malice aforethought with intent to murder and maim. We know in Townsend, there was an intent to kill requirement. For malicious throwing of acid, there has to be malice aforethought with intent to murder, maim, or disfigure. For malicious assault in a secret manner, which this court has ruled on, that included a specific intent to kill. And that case was an unpublished case, United States versus Smith from 2016. But in each of those instances, there was that separate, element of an specific intent to kill, a specific intent to maim. And here we don't have that. We have to presume that the legislature knew.
You say there's not a specific intent to kill or maim, but the statute talks about inflicting physical injury, which would seem to be right at the heart of the elements clause or the force clause.
Your Honor, Townsend actually required the exact same element. And in Townsend, this court concluded that the specific intent element went to the specific intent to kill, not additionally adding a specific intent to commit physical injury. And so here, I think that is identical to the Townsend physical injury element that this court did not extend an additional mens rea to. The actus reus of strangulation here does not import a new mens rea onto the act of strangulation.
But the addition of strangulation has to be given some significance. And yeah, sure, if you had said strangulation with intent, maybe we wouldn't even be here. But I don't think you have to use those words if the conduct that is specified as an additional element, or this is my question, if the conduct that is specified as an additional element necessarily requires intent. Assume that was the case. I know you dispute, but if it necessarily requires intent, wouldn't that be enough that we would say, you can't commit this crime negligently or recklessly? If you assume with me right now, strangulation can only be committed intentionally or purposefully. Wouldn't that in your argument?
Your Honor, I don't know, because first of all, I think, as I noted, the North Carolina Supreme Court and the state courts haven't really addressed this issue other than in State v. Lanford, in which the court said that they were not boxing in the statute to any particular method of strangulation. And so I think that it's difficult for me to hypothesize here. I mean, I think
but I'm not asking you to right now to say whether we can come up with something, but if we just take as an assumption, and believe me, I know you disagree with it, so I'm not trying to put words in your mouth, but if you take as an assumption that a strangulation must be committed by purposefully or intentionally, wouldn't that prevent your appeal from succeeding?
I think if the statute was clear as it was in Townsend, that there was a specific intent to commit strangulation.
So you're saying conduct, even if you assume it can only be committed intentionally and purposefully, that would not be enough to resolve the appeal?
Yes, I think that's correct, Your Honor. And I think the reason that I say that is because of the way that North Carolina has drafted its other assault statutes.
It makes, I mean,
Can you give me just an example of one case, just one case that has been submitted to the jury under this statute under a recklessness or culpable negligence standard? I'm just looking for one case.
In North Carolina, Your Honor, I do not have a case. And I think we
Well, doesn't that matter if you can't even think of a single case under this statute that has been submitted to the jury on a negligence and you've got 23 cases where the mens rea has been pellucidly clear that it required intent or knowledge. And so we get farther and farther away from what actually happens as a practical matter on the ground. And we ascend into the high clouds of theory and say, well, this is analogous or this might happen and everything. But when we get down to it, you got 23 cases where the mens rea has been submitted clearly as knowing or intentional. They don't fool around. There's no ambiguity about those instructions. There's a mens rea of knowledge, and you got no cases, not a one, that bolsters the theory in terms of what actually happens on the ground. That's the problem here.
Your Honor, I see my time is up. May I answer your question?
Would you like to reserve some time for rebuttal?
I would, Your Honor.
Okay, thank you. Mr. Enright.
Thank you, Your Honor. May it please the court, Anthony Enright for the United States. The district court properly held that assault inflicting injury by strangulation under North Carolina law qualifies as a crime of violence under the sentencing guidelines. I don't think there's any dispute that it requires a degree of force that matches the force clause. And it also requires a mens rea that's sufficient under the force clause because this court looks at the minimum conduct that the state would actually punish, and that minimum conduct requires at least purpose or knowledge, what the law ordinarily refers to as intent or actual intent. And a darn good indicator of that is 2 decades worth, almost 2 decades worth, of an unbroken line of decisions applying it exclusively to unequivocally purposeful or intentional conduct. Now, as Judge Quattlebaum mentioned, that's not always determinative. When you have the plain language of a statute speaks directly to it. If the statute said assault inflicting injury by negligent strangulation, that would be a much more difficult case for us. And I think it would be more difficult for the defense if it said intentional strangulation or purposeful strangulation. We don't have that here. And it's also not determinative when the state's highest court has said unequivocally or held, hey, it applies to this scenario. That was the situation in Apparatio Sordia, and it was the situation in Salmons. It wasn't the state's highest court, or Salmons, in Simmons. The state's highest court hadn't said it, but an intermediate appellate court had addressed a sufficiency of the evidence challenge to Edwogo, a different assault statute, and said, well, it satisfies the culpable negligence standard, so that's enough. We don't have that here.
You say we don't have that here because Jones is referring to assault generally, and there's no appellate court that approves or endorses a negligent or reckless charge with respect to assault by strangulation.
There's no appellate court that endorses that with respect to this offense, assault inflicting injury by strangulation. On Jones, I think we agree, but I want to qualify it a bit because Jones held that there are some assault offenses that require at least general intent, which is awareness of the facts that make your conduct a crime, not culpable negligence, or specific intent. There were 2 of them that identified assault with intent to kill and assault.
We're dealing with a categorical approach, aren't we?
Yes, Your Honor. Absolutely. So we're looking at the
issues of visibility or indivisibility or anything like that in this case.
No, I don't think there's any quarrel about divisibility.
So it's categorical approach. That's what we're looking at.
Categorical approach.
I mean, you can't look at the facts underlying this event.
You cannot.
Okay.
No, but you can look at the elements. And when you're looking at the elements, you look at the minimum conduct that the conduct would actually punish. And I think the cases speak loudly on that point.
You say it can't be committed negligently or recklessly.
It can't be
as a matter of law.
As a matter of law, and as Judge Wilkinson mentioned, it's not the assault element that we have the issue with. It's the inflicting injury by strangulation. Those elements cannot be committed with anything less than purpose or knowledge. One of the reasons is not just the cases, but that's what logic suggests. It naturally is very difficult to describe one person, because there has to be an actor here. There has to be a defendant and there has to be a victim. It's very difficult to naturally describe someone as strangling another or assaulting another, inflicting injury by strangulation in a way that is negligent, that is culpably negligent as to the strangulation. The defense points to this New Jersey case called O'Carroll, but that case didn't hold that New Jerseyans believed that people strangled people negligent. What it explained was that you can strangle people with recklessness as to whether that would cause a death. In other words, you intend to strangle somebody, but you don't expect them to die. In that case, the defendant was defending. I wrapped a cord around the victim's neck to stop her from stabbing me with a knife. And I was not sure she was going to die. The defense was not, I didn't know had the telephone cord or the neck was there. It's counterintuitive to the point of perhaps absurdity to speak of a negligent strangulation. And it's difficult to see what purpose that would serve. If you think about the car accident analogy the defense has used, it would be a defense. You could say, well, I knew I was negligently driving that car. I was going 80, or recklessly driving that car. I was going 80 in a 25-mile-an-hour zone. But I didn't foresee the seatbelt wrapping around the victim's neck as a ligature. And that would be a defense if culpable negligence were the standard.
Well, I mean, I can see plenty of cases where you negligently strike a police officer's car, but and that's what the defense is pointing to. But to me, there's a world of difference between hitting another car and taking another human being and strangle them and inflicting physical injury on them. I mean, those seem to me to be like comparing apples and oranges. I mean, car accidents are classic cases of negligence, and that's what Simmons is all about. And nobody would ever contend otherwise. And it doesn't matter whether it's an officer's car, it can be struck negligently. But this is a totally different situation. This is taking another human being, strangling them, and inflicting physical injury. And the person there had to know what they were doing. That's not negligence. They knew what they were up to. And all of the cases and the jury instructions and the submitted cases reinforce that very basic point.
Absolutely, Your Honor. And I think the jury instructions, especially, they do corroborate that. I do want to respond to the defense point about them being identical. I mean,
are the jury instructions the law of North Carolina?
Well, the jury instructions, in this case, we have the jury instructions quoted with approval by an intermediate appellate court in Brixton.
I thought you didn't answer my question.
Oh, I'm sorry.
Let's not be able to hear. Are jury instructions the law in North Carolina?
Well, they're evidence of the law, Your Honor. I'm sorry if I don't understand your question.
It's a yes or no answer, I think.
Well,
they're not.
I don't believe that the court is absolutely.
It might be carry some weight here. I'm not saying they don't. It seems like everybody's arguing about jury instructions. I mean, jury instructions. I mean, lawyers fight over them before they go to the jury, and the judge bends them and changes them. I've been in the courtroom a few times.
Oh, that's
something about jury instructions.
I I apologize, Your Honor. I didn't understand your question. No, I don't.
My question was, are jury instructions the law?
I don't believe
You got recommended jury instructions probably that some committee of lawyers wrote up or something.
Yes, Your Honor.
That kind of thing.
In this case,
that are sent to judges and lawyers to help them out as they go through cases. But most of the time are not adopted by the legislature and signed into law, I think.
oh, that is absolutely true. They were not adopted by the legislature. I do think in this case they accurately state the law, and we have some evidence beyond their mere existence of that because we have State versus Brixton upholding the jury instruction.
You're citing them as if they are the law. That's the way I've read it, and I just wouldn't understand that.
I don't mean to do that, Your Honor. What I think they do is they show good evidence of how.
It almost sounds like you're getting into what the modified categorical approach.
I don't think so, Your Honor. Even under the categorical approach,
That's where you can look at the instructions and the indictments and the plea agreements and all that stuff.
So I'm using them for a somewhat different purpose here, which is as evidence of how, in practice, these cases are prosecuted.
Who wrote them up?
North Carolina.
Tell me that. Who wrote these jury instructions that you're relying on?
I believe it's a committee that has input from the courts.
A committee?
Yes, Your Honor.
Some committee of lawyers and judges?
I believe so.
Were they promulgated and approved by the Supreme Court of North Carolina or by the legislature?
I don't believe so.
Okay.
That said, we do have some evidence that they are rather routinely used. And the court is, a trial court, its obligation is to accurately instruct the jury as to the law. And here they were upheld in the United States versus Brixton. And I don't want to belabor the point, but I do mention that they are different in the assault by inflicting injury.
I mean, Judge King is correct. They're not law in the sense that they haven't been adopted by a legislative body and they haven't been formally incorporated into a court opinion. So I guess you were using them as just one point of illumination, along with many others, which are more significant. But I think that, Judge King is right. We can't just lean and rely on the jury instructions as if they are a matter of law. He's got to be correct in that. They're at most a bit of illumination as to what the North Carolina statute requires.
Absolutely, Your Honor. These are all points that I think this court should consider together. You have a unanimous body of cases. Over the course, it is a relatively new statute, but it's still been around for 2 decades almost.
How long? When was it adopted?
2004, Your Honor. You have the jury instructions. And you have what I think several of Your Honors have alluded to, which is it strains ordinary use of language to construe it differently. And this court, the Supreme Court, or the Court of Appeals of North Carolina in Brixton held, we interpret this statute consistently with common sense, this particular statute.
So repeat that, please. We interpret it consistently with what?
Common sense, sure.
Yeah.
The common sense does play a role in the interpretation of statutes. And against that backdrop, it's against that backdrop that we have the absence of any cases applying it to a lesser mens rea. We have the absence of any legislative pronouncement that a lesser mens rea is sufficient. We have the absence of any attempt to apply it to a lesser mens rea, and we have the absence of even any dicta in one of these cases applying this statute stating that a lesser mens rea is sufficient. And it's under those circumstances, I think this court can say with confidence that there's no realistic probability that North Carolina would prosecute as assault inflicting injury by strangulation, an offense that requires less than purpose or knowledge. And if the court has no further questions, I'll yield the balance of my time back to the court.
All right. Any further questions? Judge King, do you have any further questions?
Fine, Your Honor.
Judge Quattlebaum, do you have any further questions?
No, I'm fine too. Thank you.
Thank you, Your Honor. I will be.
Ms. Hoffman, you have some rebuttal time.
Yes, thank you, Your Honor. I will be brief. I just would like to address a couple of points that the government made. I agree with the government that the jury instructions here inform our inquiry, but I think that's also why the statutory language is muffled, why the statutory language is so important, because the only other case in which this court has found, well, the only other two cases in which this court has found an additional intent element has been in Townsend, and it has been in the unpublished case of Smith that I mentioned, which was the assault by secret.
But counsel, the overall lesson that you get from the Supreme Court is there should be some realistic possibility that North Carolina would use this statute in the way that you say it might. In other words, that it would use it in a culpable negligence situation. And those are the words, I don't know whether it's Duenas Alvarez or whatever, but the court doesn't want us to stray that far from common sense. And therefore, they ask this question at the end of the day: is there a realistic possibility that North Carolina would seek to prosecute these cases on a culpable negligence theory when they have never before done so?
Your Honor, I think that if this court were to find that, it would be in direct contradiction to Simmons and Aparicio Soraya.
No, because we have indicated that Simmons, there is a realistic possibility that someone could ram into a police car and never intended to do so. This relies so much on Simmons, and that is just a very, very different situation, because everybody agrees that car accidents, a lot of them anyway, involve negligence. But I don't understand, because you can't transfer running into a police car with somebody who's strangulating somebody and inflicting physical injury on them. The one person might not intend what was doing. The other person could not help but know what he was or she was doing.
Your Honor, I think in the car accident example, which we provided as in our briefing, in a car accident, someone could be hit and strangled with the seatbelt. We provided two cases, not in North Carolina, admittedly, in which there were assaults that were determined, and as part of the injury, it was determined that the person had been strangled by the seatbelt. I don't think that it is outside the realm of common sense for us to look at those examples. I think if I can.
No, we're not talking about strangulation by a seatbelt, and those haven't been submitted under this statute.
But it could be, Your Honor, and that's the point of the categorical approach. The categorical approach says that if the possible conduct falls under the realm of the generic offense.
That's right, but you can't, the possible conduct can't be just purely imaginary. It can't be a figment of the imagination. The possible conduct has to have some roots that are anchored in reality.
Your Honor,
that's what they're saying. That is that you can't go and just theorize about this and that. There has to be a touchstone in reality.
I understand, Your Honor. If I can just make one further point here on the instructions, I would note that in Townsend, this court noted as another example that affirmative defenses to the offense were voluntary intoxication. And I would note that in doing my research in preparation for the argument yesterday, I did locate an unpublished North Carolina Court of Appeals case, State versus Stevens, in which it determined in an APHIS case, a physical injury by strangulation case, that a voluntary intoxication instruction is not permitted because it is not a specific intent offense. Of course, we know here that we have been arguing that it is a culpable negligence offense. And again, while the instructions are not the law, they do inform here. And I think where this court found, excuse me, I'm just about over. I'll end here unless there are any other questions.
No, please finish your point.
Thank you, Your Honor. I was just going to end by saying that in Townsend, when this court found that it was an important element that an affirmative defense such as a voluntary intoxication could defend against that particular offense with the specific intent to kill element, that the North Carolina Court of Appeals in State versus Stevens, which is 725 Southeast 2nd 922, that a voluntary intoxication instruction is not appropriate in an APIS offense. And for that
All
reason,
right.
yes, Your Honor.
Thank you.
Judge Wilkinson, can I ask one follow-up, please? Counselor, you had said in response to one of Judge Wilkinson's questions that Supreme Court tells us that we should look to see whether there's a reasonable possibility that North Carolina would prosecute for culpable negligence. And you said that'd be inconsistent with Simmons. And there was discussion. I understand that point. I think you were going to say another case, and I just wanted to make sure I had that case for any further review I'm doing.
It was United States versus Aparicio Soraya, Your Honor. And also in our briefing, we listed United States versus Titties, Ramos, which is a 10th Circuit case, Ramos versus General, which is an 11th Circuit case.
I appreciate the case, so thank you.
Thank you very much.
Your Honor.
Thank you both very much. Sorry we can't come down and shake your hand, but we appreciate it. Appreciate your being here.
Thank you very much.
All right.
Thank you, Judge Wilkinson, and may it please the court, Jeff Forney for the appellant, Felipe Perez. The district court abused its discretion in this case in determining that the government was substantially justified in imposing on a state court custody order a finality or permanency requirement relating to the non-viability of reunification of one or both of the parents. The district court abused its discretion by misapplying the reasonable person standard. It ignored three critical flaws in the government's defense. It cannot, taken independently or as a whole, be justified to a degree that could satisfy a reasonable person. First, the government's decision and the arguments defied the plain meaning and explicit verb tense in the statute. Second, the government intruded upon a sphere reserved to the state pertaining to domestic relations orders contrary to related precedent. And third, the government relied on a defunct regulation to support its position that was plainly at odds with the statute. And of course, misapplying the law is an abuse of discretion in this circuit. And the decision denying each fees in this case was legally erroneous. Take the first defect in the government's case. USCIS's decision below and in its own terms.
Because your opponent says you're atomizing the government's case. You've got to look at it as a whole. And these 3 and 4 points that you bring up are subsidiary points to the government's overall theory of the matter. What do you say as to that? Are you atomizing it, or are you dividing and conquering, or what?
Well, the standard, of course, is you need to take the case as a whole, of course, and that's what we've done. But in order to understand the whole, you do have to look at the parts. And taken in the aggregate, the government was not substantially justified. You need to look at each of the component parts of their argument. And when you take each of them and then put them together as a whole, neither can be substantially justified. The first is not substantially justified on the point of permanency because this court sitting on bonk found there is no permanency requirement. In fact, that's plainly at odds with the statute, namely the verb tense. And
So,
of course,
if I could interrupt, I mean, we've had a good debate about this case for years, and appreciate all that. And our court has spoken, it's en banc opinion. So I certainly respect that. Even though I, was on different side of that. That's our law, and we're bound by it. But it is the fact that that was the outcome? It feels like your argument is because of that outcome, necessarily the government's position was unjustified. And, you know, we had a pretty good debate about issues that, you know, obviously different folks looked at differently, but a number of judges and the district court and others have had a different view. And, you know, I don't think anyone thought the others' positions were frivolous. So I'm in a context like that, where there is a, you know, reasonable debate about something that has not been specifically addressed by binding precedent. How is that not a justifiable position to take?
Thank you, Your Honor. Yes, the government's defense, at least in this particular matter now on the Egypt question, has been primarily that it was a novel question, not addressed before by this court, and therefore they were legitimated in pushing forward the issue because they claimed there was no authority sort of guiding them. That's not quite accurate. First problem with it is that it can't be the case that if a federal agency, which of course is a creature of statute and must be bound by the statutory law that creates it in its organic statute, if it flies in the face of the plain meaning of that statute, ordinarily you would have to conclude that that in itself shows that there's no substantial justification, especially in the world in which we live now, where you know, the text of the statute controls. That is the basis for which
it said this thing had to be a permanent custody order.
Right.
Were they entitled to defend that, the government?
No,
They weren't entitled to defend it.
they were not. On two grounds. First,
This thing is that you said at the outset, we review the district court's decision for abuse of discretion. And
Yes.
what's your theory of how the district court abused its discretion? Are you pointing to an error of law or errors of law or what? I don't know what you're getting at.
Mm-hmm. Yes, thank you, Your Honor. Well, the point is that the district court abused its discretion in misapplying the reasonable person standard. Of course, that is the standard under EJA with substantial justification. And a misapplication of law or a binding standard is an abuse of discretion. But that's the argument.
But the district court, I mean, to follow up on Judge King's question, listed, you know, some of the law that was in the Fourth Circuit at the time, the Reyes decision. I think it addressed the OHO decision that we had a good debate about. It talked about the ways that the agencies and the district courts and, you know, our panel had looked at it. And, you know, that sounds like that the court's looking at factors to try to come to a conclusion about substantial justification. And to Judge King's question, why is that? I mean, you might have a different view of how that was resolved, but are those factors that just are absolutely as a matter of law, you know, outside the bounds of what can be considered?
No, those are factors that must be considered. The way in which the court addressed it.
Has it abuse of discretion?
Because the law that the district court analyzed was incorrect. The Reyes decision did not support the government's position in this case. I know the government has pressed that in this case and it did below. But the Reyes decision, it's unpublished, but in any event, it was a decision from this court, actually upheld USCIS's decision, but in part on the ground that it agreed that USCIS's refusal in that case to accept a post-order affidavit would have improperly intruded upon the state court's domestic relations order. And so USCIS was already on notice in that case, Reyes and in OJO, that it was inappropriate for the government under the wording of the statute to impose extraneous conditions for review de novo this state court domestic relations order. And that's exactly what it did in this case. District court, that was sort of lost on the district court, and that point wasn't discussed by the district court in the EJ decision. So that's one fatal error showing an abuse of discretion. The other problem is that the court didn't address.
Counsel, it sounds like to me you're arguing that the government's position was wrong, and this court has spoken on that question. It was wrong, but this statute, and I think as Judge Quattlebaum said, we all accept the fact that our position in that case was a losing one and that we're bound by the majority's holding. But at the same time, this statute was not written in the way that 1988 was written. It's not just a purely prevailing party statute. There's a clause unless the government's position is substantially justified. And I don't think we can just jump immediately by virtue of hindsight to say that something that was uncertain at the time became certain as a result of the court's in-bank ruling. But that doesn't mean that the government was clairvoyant or prophetic enough to understand that it ultimately would not prevail in a close case. We're looking at this with the benefit of hindsight because we know who won. But the parties before the case were struggling with a very difficult question, which was how that emergency order ought to be interpreted. And you did have 6 judges on the court, or however many in the district court, that interpreted the statute one way, and then you had 9 judges in the majority that interpreted the statute another way. But when you get this close a division, we were trying to figure out what effect the emergency order would have under South Carolina law, and whether the parental reunification, the absence of parental unification authority was prevented the order from qualifying under the SIJ status. All I'm trying to suggest, Ruth, is it was a hard case. And losers in hard cases, it doesn't mean that their position isn't substantially justified. That's why we have an adversary process to resolve the hard cases.
Yeah. Understood, Your Honor, and I agree with everything you said. That's not the argument we're making. We're not saying just simply because the plaintiff in this case prevailed that they are entitled to an EJ award. No, the government does need to show that they were substantially justified. They didn't do that, and it's not because of hindsight. It's because if you look at the case and how they prosecuted their defense and the arguments they made were not justified by a reasonable person's standard. And it doesn't simply have to do with the fact that there was a disagreement over the meaning of the statute. Of course, it was the plain meaning of the statute and the government lost. But what is more critical is the other attempts they made to justify their position. For example, using a defunct regulation that they knew was no longer operative because the statute had changed. In fact, they latched onto the very terms in the regulation that were borrowed from the statute that had been superseded. It's black letter administrative law that when a regulation based on a statute, and that statute has changed, the regulation is no longer in effect. No reasonable administrator is going to operate their program under a defunct regulation that has been superseded by statute. Yet still, the Justice Department pressed that point continually, convinced the district court of that, likely leading the district court down a primrose path about that regulation, and then continued to press that point on appeal, knowing full well that regulation was not in effect and could not justify any permutation of its permanency argument, which had shifted from one permutation to another throughout the case. But the common element there was that they recurred to a defunct regulation. And that cannot be substantially justified. They knew full well that that regulation was not in effect. They should not have used it. And on that basis, you see that they just could not be substantially justified. And that taken in conjunction with the other problems in the government's case, we've been discussing the statute on the verb tense, but there's another problem, of course, with how they construed the custody rule. This court had already determined in Ojo and discussed relatedly in Reyes, a case on which they rely, that they're not supposed to be imposing extraneous standards on domestic relations orders because those issues are reserved to the state. And that's exactly what they presumed to do here. They were told not to.
No, they were just asking, they were asking a hard question, and that is, what effect would the North Carolina courts give to the emergency order, and whether the North Carolina court lacked jurisdiction or whether it had jurisdiction to establish custody in the emergency order. And the question was whether it had jurisdiction to rule on the matter of a reunification with the parents, which was critical in determining whether the order qualified the petitioner for SIJ status. And all I'm suggesting to you is that was a tough question. It was a hard question. It was not a gimme. It was not a lay down. And, I'm sure the government is perfectly willing to accept the fact that the view it's expressed turned out to be the minority one. It was an incorrect one. And everybody understands that. But if you put yourself back in the shoes of lawyers who didn't have the benefit of the court ruling that we now do, they were struggling with the hard question, and that is the effect that North Carolina would give that emergency order and how that lined up with the SIJ status. And we were all wrestling with that. And Judge King and Judge Quattlebaum wrote very fine opinions. They both did. They disagreed. That doesn't mean one of them or the other of them was unreasonable. That's what I can say. I said a bystander would look at their good debate of my colleagues and say, yeah, these are good judges dealing with a close case and a hard case. And that doesn't make one side unreasonable, because it's the job of the adversary process, particularly at the appellate level, to resolve the hard cases. That's all I'm saying to you. Is I've taken up a bit of your time, so if you have something to add, I'm happy to lapse into silence.
Thank you, Your Honor. Those points are much appreciated, and I do agree with you that, of course, in retrospect, things have a different texture.
Mr. Forney, I've practiced law for a long time, and as part of this adversary system, I always thought that each side should be zealously represented in order for the system to function properly. And I wouldn't want to do anything to jeopardize that system. at all. I mean, this is a minor, this statute fine tunes it a little bit in dealing with the government, and maybe it places a little bit more of a burden on the government. But lawyers have to be encouraged to be willing to step forward and take sometimes unpopular positions or tough positions, and argue on behalf of their party, unless there's some special rule that makes the government lawyers different than the private lawyers completely, which I don't know of.
Well, there are special rules. Well, this statute does sort of impose a special rule. You could be a zealous advocate, but it has limits.
Let me finish.
I'm sorry, I thought you were done, Your Honor. I apologize.
Judge Wilkinson and Judge Quattlebaum are my friends and colleagues, and we had an intense debate concerning this case over an extended period. But we respect each other's positions, and we respected them, and we continue to respect them. And each side was represented by good lawyers. And I'm reluctant to start shifting fees just because of one side lost and the other side won, as to what it's going to do to the adversary process.
Well, I have to apologize. I'm sorry. Is someone else speaking?
There's an exception to it, and that Judge Conrad abused his discretion some way or another.
Well, I do have to apologize to the court because apparently I have not made my point clear. And so let me just wrap up by saying I am not suggesting just simply because the plaintiffs won that they are then entitled to fees. And I'm not saying that, there wasn't a vigorous debate back and forth, but it just wasn't justified on the government side. And in part, I've discussed the issues, I'll leave it there, but I just have to reemphasize the point that it was completely unjust and improper for them to recur to a defunct regulation, knowing that it was not in place, and they were pursuing an outcome at all costs, which is apparent from their briefs. And that's the type of advocacy that I think EJA statute attempts to limit in order to level the playing field between the large federal government with its infinite resources and individuals who are up against that.
All right, thank you very much, counsel. All right, let's hear from Ms. Wall. We'd be pleased to hear from you, Ms. Wall.
Good morning, Your Honors. May it please the court. Shatul Wall from the Department of Justice on behalf of the United States Citizenship and Immigration Services. First, I'd like to say good morning, Judge Quattlebaum. It's good to be here again. This was your very first case on the bench and my very first oral argument in the appellate court. So glad to be back here with you and back from Georgia, Judge King. Good morning, Judge Wilkinson. Judge Wilkinson, you are absolutely correct. This was a very hard and complex case on the merits. Fortunately for us, this is a straightforward, easy EJA case. Government was substantially justified. Judge Conrad absolutely did not abuse his discretion here. And we asked that this court affirm Judge Conrad's decision to deny Mr. Perez's motion for attorney's fees. The statute allows plaintiffs' motions for attorney's fees when they prevail, unless the government's position is substantially justified. This court has taken a holistic view, looking at the totality of the circumstances. I will say this court in Paisley addressed this issue that Mr. Forney just mentioned, even though it's not true in this situation. But let's say that Judge Conrad did, in fact, take a view that was incorrect as to the law. This court said in Paisley, even with respect to misapprehensions of controlling law, our view of the district court's decision must be deferential in obedience to Pierce. And Pierce is the Supreme Court case dealing with the EJA statute and substantial justification. It's a deferential view that this court takes, and it's a highly strict view when it comes to the fees statute here, as Judge King said, there was a healthy debate in this case. Reasonable minds did differ. Reasonable minds took positions that were well thought out, just like Judge Conrad's opinion, well reasoned. That doesn't mean that that doesn't mean that the government's position was not justified, simply because after review from the district court, after review from the panel here, and after review from an en banc court, that position lost 9-6. Substantially justified means that the government's position is justified to a degree that could satisfy reasonable people. It's not a high degree. And let's not forget, and this goes to the heart of the plaintiff's position here, to parse out the arguments, to parse out the positions. The statute itself says position, it's singular. The Supreme Court in INS v. Jean has said what this means is that the court must make one threshold determination for the whole case. It's inclusive as a whole, not atomized line items. And so when we look at the position of the government as a whole and not individualized arguments, we come to the conclusion that the government's position as a whole was justified. In this case, plaintiff made 3 essential arguments: that the government imposed an ultra-virus permanency requirement, the government was arbitrary and capricious and not otherwise in accordance with law when it imposed that ultra-virus permanency requirement, and that the government violated the full faith and credit clause. The government defended all 3 of these claims consistently and throughout the litigation, cradle to grave. Now, Mr. Perez argues that the government did not make these arguments, that the government was not substantially justified because no court or judge ever adopted any of the government's arguments throughout this litigation. That's at page 17 of his brief. And then again at page 20, Mr. Perez argues that the government abandoned its permanency argument en banc. And this is one reason why the government was not substantially justified. However, at the record at page 375, Mr. Perez concedes that this panel's opinion adopted the government's argument and that there was no permanency requirement. Again, at the record, Joint Appendix 95 and 201, the district court and this court respectively adopted the government's argument that it did not impose a permanency requirement. En banc, where Mr. Perez says that the government abandoned its argument about the permanency requirement, the government argued it did not impose a permanency requirement, spent 5 pages on this argument. And then at 361, the dissenting judges adopted that argument that the government did not impose a permanency requirement. The next claim the plaintiff made that the government argued about the arbitrary and capriciousness, the next claim, the North Carolina statutes. This is what I wanted to talk about. The plaintiff talks about the arguments that the government made were unreasonable, unjustified. The government argued that the basis for its decision was the North Carolina statutory provisions. And the court adopted that argument at Joint Appendix 202 and 203. This panel majority analyzed those same statutes and then published that decision at Joint Appendix 202 and 203. This panel also—
Ms. Wall,
Yes.
I don't mean to cut you off, but you've written a very fine brief, and I wonder if we might at this point, let the panel see if it has any further questions of you, because you've really covered you made your points well in the brief, and you've also made them well at oral argument. And at this point, I'm going to ask Judge King and Judge Quattlebaum if they have some questions of you. Judge King,
I do not, Your Honor.
Judge Quattlebaum,
I don't have any questions either. Thank you.
and I don't have any questions either. So I don't mean to cut you off because I want you to know how much we've appreciated your argument, but I think it would be fine for you to rest on your brief.
Absolutely. Thank you, Your Honor, and I am honored. I will rest on my brief.
All right. Thank you. Mr. Forney? I think you need to unmute yourself here.
Sorry, Your Honor. Just two brief points. I just want to refer the panel respectfully to the statute, the Aegis statute 2412 D2D, which defines what the position in the United States is, and that does include the agency action under review. So part and parcel of determining whether the government's position is reasonable is looking at the agency's decision and then how the Department of Justice dealt with that decision. And it dealt with that decision in a way that was not entirely accurate. It was saying there was no permanency requirement imposed by that decision, but it in fact did such by its plain terms. So that's relevant only in the sense of the texture at which the panelists to look at what the government did in this case. The other thing, lastly, is just that it was rather difficult to understand what the government was arguing through the Justice Department on the permanency issue. It appeared to trade on an ambiguity about what permanency means. Sometimes they appeared to suggest it meant finality. Sometimes they appeared to suggest it meant a final determination about non-viability. And they appeared to go back and forth between the two. And I think that created a lot of confusion, both at the district court level and at the initial panel level. And I think that goes to the point about substantial justification, because it showed a type of duplicity that was at odds with their own decision they were defending, and an unclarity about what they were doing exactly in the case. I think those points just go to the lack of substantial justification. And I'd like to thank the court for their time today. I'll rest at this point.
We want to thank you. We want to thank you both. And sorry we couldn't all be here together in person, but we appreciate the arguments nonetheless. All right, I'm going to ask the clerk if we can move into our It'll be a pleasure to hear from you.
Thank you, Your Honor. Is it all right with the court if I remove my mask? Sorry.
You do whatever you feel most comfortable with.
Thank you very much, Your Honor. And I wish to apologize to the court for my co-counsel's phone going off. We thought we had them all turned off. He carries like 2 phones. We forgot one. Please, the court. North Carolina prohibits out-of-state retailers from selling and shipping wine to consumers, but freely allows its own in-state retailers to do so. If this were any product other than alcohol, I think there would be no question that a law that discriminates against interstate commerce in this way and protects in-state business from the rigors of competition would violate the Commerce Clause. But because we are talking about the 21st Amendment, about wine, the 21st Amendment is clearly also relevant. And the question is, the central question is how one balances these two constitutional provisions. That balance has been set in general by three cases. Granholm v. Heald from the Supreme Court, the most recent Tennessee wine case from the Supreme Court, and Beskin versus Easley from this circuit, and somewhat by Brooks v. Vassar that followed that, in which they basically reaffirmed Granholm, but then that case became moot and they didn't go much beyond it. What those cases,
Are you suggesting this is a per se Commerce Clause violation?
not at all, Your Honor. I'm suggesting, excuse me, I'm suggesting that the balance between these two provisions says that the 21st Amendment gives states broad power to regulate alcohol, but is limited by the non-discrimination clause, the non-discrimination principle of the Commerce Clause, which makes it kind of presumptively.
You say the Commerce Clause trumps the 21st Amendment?
No, Your Honor. I think that what the courts have done is tried to treat them both equally, as equal provisions in the Constitution.
Is there any other, liquor is the only commercial product that's limited or dealt with in the Constitution, basically, isn't it?
It is.
Intoxicating liquor
Right.
is the word they use. Liquors is the words they use. And they struggled with that because they had an 18th Amendment and then a 21st Amendment, and they put this Section 2 in there and said, we're going to let the states do it, right?
They did.
We're going to let the states do it.
They did. And in the first.
So transportation or importation or delivery or use of intoxicating liquors in violation of the laws thereof, that's in violation of the laws of the 50 states, right? Is hereby prohibited. So the only way you can transport it or import it into any state is in accordance with the law of that state. So you got to be consistent with the law of North Carolina on the face of the 21st Amendment, Section 2, right?
Well, that was and in the 1930s, when the amendment first came out, when it had first been announced, that was exactly the position that the Supreme Court took, was that this was essentially absolute. That
And the 21st Amendment hasn't been changed since then. It's there.
Oh, it hasn't, but
The Supreme Court's explained it maybe a little bit, but
there've been
what I've just said is what it says.
that is what it says, and then the question becomes whether there is, what the interaction.
Now, tell me about the Granholm decision. That seemed to me to be the strongest Supreme Court decision from your point of view. Why do you think Granholm supports you?
Well, because Granholm said quite clearly that the 21st Amendment was limited by the non-discrimination principle of the Commerce Clause. And it said quite clearly that if a state allows the direct shipment of wine, it must do so even-handedly. In other words, it looked at the phrase, the laws of the state, and saying, if a state outlaws any shipment or direct shipment of wine, then you can't bring it in from out of state. But if the state permits, in Granholm it was wineries, if the state permits in-state wineries, permits some wineries to ship directly, then the laws of the state do not prohibit shipment. It becomes down that they only prohibit.
All right, well, let's suppose that we were just hypothetically to agree with you that there was a constitutional violation here. There would still, you still face a real question about what the remedy should be. And so I think you have some good points to make with respect to the Commerce Clause violation. But I also think Judge King makes a powerful point when he talks about the 21st Amendment. And so the question is, I think, how do we give effect to them both? Why wouldn't it be fair to say we're going to give effect to the Commerce Clause a la Granholm by noting the stark difference in treatment between in-state retailers and out-of-state retailers. But we're also going to give effect to the 21st Amendment and its consignment to the state of broad powers over alcohol. And the state talks about its three-tier system and how important that is. And so is it possible to agree with you on the violation aspect of this case, but to agree with North Carolina as to remedy? Because what the state is suggesting here is you can achieve even-handedness here by barring in-state retailers from shipping directly to consumers. And that would be even-handed, and it would follow what the North Carolina Attorney General is suggesting. And it would follow the severance clause and the legislative intent. And it would preserve North Carolina's chief interest in this case and under the 21st Amendment in regulating alcohol through its three-tier system, which I think is a very substantial state interest. But what I'm suggesting is that I'm not sure this needs to go all or nothing. I think you have a good point as to the Commerce Clause violation, but I also think North Carolina under the 21st Amendment has a very strong point to make under the remedial aspects of this case. And what I'm looking to do is to say that there are two strong interests here: the 21st Amendment on the part of the state and the Commerce Clause on the part of the union, and not avoiding home cooking that gives in-state enterprises a distinct advantage. So you can win on violation, but don't you have a significant problem with respect to the remedy?
That was exactly the situation in Beskin versus Easley back in 2003, when this court found that indeed the Commerce Clause prevailed on the merits, that the state had not met its burden of justice.
But you suggested in your brief that the remedy here should be to allow out-of-state, to allow in-state retailers to be able to ship wine directly to consumers. That's what you suggested, right?
Yes, John.
So, and that would achieve even-handedness, but it would just carve up North Carolina's interest in its three-tier system, and it would undercut the state's interest under the 21st Amendment. So our federal union has a dormant Commerce Clause interest that I think Supreme Court cases like Granholm underscore, but the state has a very strong interest in the 21st Amendment. And why not try to reconcile them in a manner that gives effect to them both? I know you don't agree with that because you want the remedy to be to allow out-of-state retailers to ship directly to consumers, but that really tears up the state's interest here and their three-tier interest in being able to regulate and tax, both regulate and tax alcoholic beverages. And they can do that much more easily through their three-tier system than by expanding all these exemptions. So what's wrong with that?
Two things. One is to make it clear, if the Commerce Clause and the basic principles of the non-discrimination principle is right now, North Carolina statutes, their General Assembly has already decided that it wants to allow in-state retailers to ship. They've already passed that statute at HCB 10014. Then they also have a statute that says out-of-state retailers may not. One has to strike one or the other. So it is not the situation that striking the ban on out-of-state shipping is striking one statute. If you strike the ban on in-state,
No, but if you say the only remedy here is to allow out-of-state retailers to ship directly to consumers, what in the world does that do to North Carolina? Because you have really here, they say 8,000 licensed in-state retailers, and you have 400,000 in the out-of-state retailers, and so if we say, oh, you've got to allow all of these out-of-state retailers to ship directly, that's very hard to for the state to be able to keep track of and regulate and do all those things. And the state does have a real interest here in regulating alcohol abuse. And you're going to fling it wide open. You're going to let retailers sell to underage consumers, or maybe you say you wouldn't, but it sure becomes easier if 400,000 out-of-state retailers, who knows how they would, what they would do. It's just that there's a way it'd be harder to tax, it'd be harder to regulate, licensing schemes. And all I'm suggesting to you is there's a way to vindicate both constitutional provisions that afford substantial protection to the legislature's intent and the Attorney General's representations.
Counsel, could I, maybe along both my colleagues' points, doesn't the three-tier system itself, which I know there's different views of it, but I think the Supreme Court has largely endorsed the basic structure of a three-tier system. And doesn't the three-tier system itself, by its very nature, discriminate against out-of-state retailers?
Well, you mean a specific state's three-tier system rather than the three-tier system?
Yeah, I mean, yes.
Because in North Dakota, they were kind of endorsing, their endorsement endorsed the three-tier system as a general thing, and then quite specifically said it is legitimate as long as it does not discriminate against.
But if you have a system, a three-tier, I realize the court has said look at them individually. I think that is fair, and I realize the court has said that not every provision associated with it automatically is good or is constitutional. But the basic notion of those systems are that you divide the production, the wholesale, and the retail, and that the wholesale and the retail are done by in-state wholesalers and retailers, which prohibits out-of-state retailers from engaging in that. Isn't that clear?
That's just restating discrimination against out-of-state interests. There's a difference from, ownership from retailers has come through the three-tier system, a wholesaler and retailer in another state. Now, North Carolina has no three-tier system for wine. It allows wine to.
I got that argument, and that's potentially a fair point, that once you kind of make the rule you have about producers, maybe that's an issue. I want to ask about that. But on the retail side of it, the three-tier system already discriminates against out-of-state retailers. And it seems to me if the court allows that as a general proposition, how is it more problematic to allow the in-state retailers who already have that benefit under the three-tier system to do it directly versus through a retail store?
The problem is it protects the in-state. I mean,
I know, but the three-tiered system itself has some protective benefits, and the court has said it's also got some public health benefits. I mean,
the court has also said that the state to ban totally, rather than bringing them into the system. The total ban requires a proof that non-discriminatory alternatives would not be effective. Tennessee Wine spends 7 paragraphs talking about alternatives. Beskind and Granholm talk about the need for the state to not just to say, that's all they've done. They've said this is important, but they have no evidence as to why. They have no evidence.
Well, Tennessee's talking about something that the court said was a non-essential element, which seems, like I understand that. The 2-year residency requirement doesn't really, they had arguments in the court, talked about it being a non-essential element. But isn't a retail, limiting retail, whether it's direct shipments or just at a store, isn't that an essential element of a 3-tiered system?
No, what the court said, the court looked at whether something was essential by asking 2 questions. One is it used most
You didn't
places?
answer Judge Qualbon's question.
Excuse me, I apologize. I thought it was answered. You asked, isn't it essential?
Isn't it essential to a 3-tiered system that the retailers are in state?
No, 16 states don't require it. That's exactly the test the court used in Tennessee Wine. As to the residence requirement, their sentence said a number of states don't require
What is essential?
It cannot be essential.
Tell me the essential parts of a 3-tier system from your standpoint.
The essential parts of a 3-tier system, according to
you,
first step, a manufacturer must distribute to a wholesaler. North Carolina doesn't require that, so they have no 3-tier system to begin with. Second step is a wholesaler must distribute to a retailer to prevent vertical integration among the tiers. The fear back at the time of Prohibition that producers, mostly beer producers, were.
So you're just saying wholesalers, they have to be separate. You're not saying, you're saying the moment you put a residency requirement in there, you've gone outside the essentials of a 3-tiered system?
They have to be licensed. It's a licensing system to separate the tiers.
Okay, I understand your position then. Thank you.
Well, I thought your position, and I really appreciate my colleagues' questions, which I thought were excellent. But I thought your position was that they had, in permitting direct sales from wineries to consumers, that the state had already varied from its 3-tiered system, and that if you're going to vary from the 3-tiered system, you don't have to vary from it at all. But if you're going to vary from the 3-tiered system, you can't do so in a way that draws stark differences between in-state and out-state retailers. Now, it's up to North Carolina how they want to achieve even-handedness, but I thought your point was, yes, the state has a very strong interest in the 3-tiered system, but they have distinctly varied from the 3-tiered system here, and they've done so in a way that differentiates in-state and out-state. But I would carry it one step beyond, because I think there's a way to vindicate both the essentials of the 3-tiered system and the essentials of the Commerce Clause. And it's a funny thing because when you read the briefs, North Carolina doesn't really seem to object to that. They said if if there's a Commerce Clause violation here, go ahead and even it up by allowing by prohibiting in-state retailers from selling directly to consumers. And I know you don't want to go in that direction, but I think we are obliged to respect North Carolina's interest under the 21st Amendment. But my only point is that the North Carolina's three-tiered system is very important. I think it's a very important system. But if they're going to vary from that, they can't do it in a way that just starkly, they can't say, well, we have a three-tier system, but oh, hey, we're going to vary from it. And we're going to do so to the detriment of out-of-state concerns. That's the difficulty, you see?
Yes, and in Beskin, it essentially was sent back to the legislature to decide which they wanted to choose. Let everyone ship or go back to the old system where you could only get your alcohol at the neighborhood store. And what they chose the last time in 2003 was wineries, to let all the wineries ship. They acted within 6 months. Legislative intent, we now know, at least we have a suggestion as to what the intent of the North Carolina legislature is. It has steadily expanded.
All right. Okay. Thank you very much, sir. You have some rebuttal. If Judge King or Judge Quattlebaum has any further questions, we can, otherwise we would just save all that for rebuttal. All right.
May it please the court, I'm Ryan Park from the North Carolina Department of Justice, and I represent Hank Bauer, chair of the North Carolina Alcohol Beverage Control Commission. To pick up on what the discussion with Judge Quattlebaum directly, I don't think there's any way to read the Supreme Court's jurisprudence on the 21st Amendment other than that discrimination that is inherent in the three-tiered system and its essential features is unquestionably legitimate. And there are two essential features that the Supreme Court has expressly validated, and they're both relevant here. First is in Granholm. This is page 489 of that decision. They said explicitly that states requiring retailers to purchase their alcohol from in-state wholesalers is a valid aspect of the three-tier system. And the second is the in-state physical presence requirement.
But when you say in-state retailers can ship wine directly to consumers, you cut the wholesalers out, don't you?
That's actually not correct, Your Honor. And I think
I don't understand that. You're saying that they can ship directly to consumers.
I'm sorry.
What does that do to the wholesaler link in the three-tiered system?
If you're speaking about the wineries, Your Honor, 2 points I'd make on that. This is an incredibly narrow slice of the overall wine market. The record is very clear on that. I direct the court to page 165 of the joint appendix, and that's plaintiff's own evidence that shows that less than 1% of the Maryland wine market is directly from wineries. And so this is a narrow exception. Well,
if it's not that big a deal, then why not go back to a pure three-tiered system and bar the in-state retailers from sending directly? Then you wouldn't be up here. It wouldn't be any Commerce Clause problem. And you say, I mean, it may be just a narrow slice, but it seems to be awfully important to you. I don't have any problem with, and I love the three-tiered system. I think it makes an awful lot of sense. What troubles me is when we allow carve-outs that seem to me to directly conflict with basic Commerce Clause principles. That's what it's these carve-outs, and once you let the carve-outs get going, you're going to have your cake and eat it too. Oh, we have our three-tier system and we want you to vindicate it, but at the same time, we want the freedom to vary from the three-tiered system in a way that disadvantages out-of-state enterprises.
If I could separate out the direct from winery shipping and the direct shipping from retailers, these are two separate restrictions, and the direct shipping from retailers, which is the primary focus of B21's case, is not a carve-out from the three-tier system. So they would like this case to be about differential shipping requirements for in-state and out-of-state retailers, but that fundamentally misunderstands North Carolina's regulatory scheme. All out-of-state retailers are banned from making sales to any North Carolina consumer. And so if they're banned from making sales, that's an inherent aspect of this three-tier system, and shipping is merely an adjunct to a lawful sale.
But to the extent we consider, because your colleague makes the point, Judge Wilkinson makes the good point, that the Supreme Court has given a close look at exceptions to the three-tier system. And isn't North Carolina's exception on the winery example available both to in-state wineries and out-of-state wineries?
That's correct, Your Honor.
So to the extent North Carolina has an exception to the three-tier system by allowing wineries to sell direct, that is not discriminatory. It applies in-state now. Is that right?
That's correct, Your Honor.
And your point that while there is a difference in-state and out-of-state retailers, you acknowledge that, but that's the way it always is in three-tier systems. And this is just an additional way retailers that are in-state can sell their product.
That's correct, Your Honor. That's our basic position. And to elaborate on the wineries exception, if I may, at the time of Granholm, Michigan allowed for in-state and out-of-state, for in-state retailers to direct deliver, including on orders that were consummated online. And that was pressed by the challengers in Granholm, and the Supreme Court still validated the three-tier system. And so I think the basic framework that Your Honor laid out is the state's position that if there's going to be an exception from the three-tier system, that has to be fair. But within the system, if there's discrimination inherent in the system, then that's authorized by the 21st Amendment.
You know, I find this hard. I find Granholm and Tennessee wines hard. So I'll just say that to everybody. Maybe as other folks have an easier time with it to me. And it seems, as best I can tell, the issues we just talked about is, is it essential to the three-tier system becomes important. And if it isn't essential, like the 2-year residency requirement, there is a rigorous analysis. If it is essential, and a lot of the factors, quite frankly, that you say are the reasons for this thing, are things the Supreme Court has kind of been skeptical of. So, even if we might think they're reasonable, the Supreme Court says you can accomplish them other ways. So as best I can tell, this becomes an issue of what's essential to the three-tier system. And we have to decide whether a retail seller requirement is, or as your counsel say, that they're right. Not every state requires that. Maybe it's just that you separate them. Why are you right there? Why is not the fact that 16 other states or whatever other states don't require that? Why is that take it out of the essential category?
So I agree, Your Honor, that there is likely to be some sort of common law of what constitutes an essential feature of the three-tier system, and that might be how these cases progress. But we do know two things. The Supreme Court has said two things very clearly. In Tennessee wine, it said, and this is 2475, that an in-state physical presence for a retailer is a valid non-discriminatory alternative. That's what the court held in Tennessee wine. And so
where's that?
Sure. I would say that, out-of-state retailers are disadvantaged by being out of state. It's always the case that an out-of-state business, simply by virtue of its location, is relatively disadvantaged to an in-state retailer, which is located within the state and presumably more amenable to taxation and presumably is closer to its customer base. So being in-state has certain inherent advantages, but the question is, should we add to the inherent disadvantages of out-state outstate concerns, a stark differential as a matter of law. And I don't know how far we go with this principle, because we can say, oh, well, in-state, because in-state retailers are advantaged, we're going to give them this advantage and that advantage and the other advantage, as opposed to out of state. And how far do we go? It seems to me that there's, you know, a little carve out here becomes a larger carve out there, and you really open the door to a very unfortunate principle, because the very coherence of this union depends upon not having trade barriers from one state that affects another. The states have important interests, but their interests are less significant when it comes to interstate trade than when it comes to regulation of things such as marriage or divorce or the normal or property law. But when it comes to interstate trade, it's different. And you made some good suggestions, Counsel, about the remedial aspect of this. You made some very good suggestions about the fact that there's a severance clause, and there's a fact that the North Carolina doesn't have any interest in just letting out-of-state retailers ship directly to consumers. You said what the North Carolina Attorney General's position is. You said this could, you've made such a good case with respect to the remedy here, which would be to strike, which would be to bar the in-state. And so there's a special interest that you want to give favored treatment to as a matter of interstate trade. But why not adopt the remedial proposal that you had? I got the distinct impression from reading your brief that you would be pretty happy with the fact that we would bar in-state retailers. It might disappoint the in-state retailers, but it would certainly, if we're talking about disappointing the in-state retailers versus North Carolina's genuine interest, which you've eloquently articulated in preserving the three-tiered system, why not save yourself a lot of trouble and just make the small amendment to the statute, and then you won't have all of these Commerce Clause problems?
If I may, I'd like to clarify that we would not be okay with that rule. I mean, it's an alternative argument on remedy, because we do not believe that there is any relevant discrimination that is not authorized by the 21st Amendment. And if I may, with respect, I think that Your Honor may be misunderstanding North Carolina's regulatory scheme. I would, recall this court's discussion in Beskin and Judge Sutton's discussion in Whitmer, that a discriminatory requirement that one similarly situated entity has to go through the three-tier system and another similarly situated entity does not, is itself discrimination. And so, I know we're talking about the remedy as if direct shipping will be allowed for everyone. But if that occurs, then out-of-state retailers will have a very distinct regulatory advantage, because I think both sides agree that the wholesaler requirement, the in-state retailer requirement, and all the taxation burdens make it much more costly to go through the in-state three-tier system, which is fundamentally the point, that the North Carolina has a sovereign interest in restraining the unrestrained flow of cheap alcohol into our state and all the public health and safety issues.
So you're telling me that differential treatment is really similar non-discriminatory treatment. That seems kind of a contradiction in terms.
Well, let me put it this way, Your Honor, that part of the reason why the state feels very strongly that the remedy that that Your Honor proposes would invade our sovereign 21st Amendment interests is because any adjunct to the three-tier system can be framed as discriminatory. There are all sorts of requirements where out-of-state retailers are completely barred from making any sales. And so if you start chipping away at North Carolina's three-tier system, you could say, well, North Carolina allows for curbside pickup at liquor stores, or allows for this variety of wines at in-state retailers. But that variety of wines is not available for out-of-state retailers. Curbside pickup is not allowed for out-of-state retailers. These are simply adjuncts to the fundamental requirement that out-of-state retailers, if they want access to North Carolina's market, they have to go through the three-tier system.
So, counsel, let me follow on one other thing I wanted to get your views on. In both Granholm and in Tennessee Wines, the provisions there were analyzed, and the court looked at whether there was concrete evidence, quote unquote, that the provisions that were being challenged were for public health as opposed to protectionist purposes. Is it North Carolina's position that that requirement is not necessary to this provision because it's an essential part of the three-tiered system? Or is it North Carolina's position that it is subject to that requirement and it has satisfied?
So if I may, both. So, I think there's a two-part test, whether there's discrimination at all that is barred. And, the Eighth Circuit said there's no discrimination at all for the reasons that I just stated. The Sixth Circuit said, we're going to reserve judgment, but go on to the second part of concrete evidence. So on the concrete evidence standard, I think we satisfy it pretty clearly. And I'd ask the court to look at the state's expert report. This is page 289 to 292. And there really could not be stronger academic and government official evidence that the three-tiered system reduces the flow of alcohol, and that has knock-on effects on a whole range of public health and safety.
But nobody is suggesting that you abandon that. Nobody is suggesting that you've got to allow out-of-state retailers to ship directly to consumers. What you're arguing about is the state's interest in not allowing out-of-state retailers to ship directly to consumers. But nobody is saying that you have to depart from that state interest. It is perfectly, you can retain all of the interests that you have talked about, the taxation, the regulation, all of those advantages, the fact that you have fewer numbers, you can curb sales to minors, everything you have posed. Nobody, absolutely nobody is saying that you have to give any of that up. All they're saying is when you get down to imposing rules of trade between the states, there's a way to preserve your own interest without starkly, and you use the word discrimination, which is sort of loaded in my view, starkly differentiating between in-state and out-of-state interests. If there's a more core principle to the Commerce Clause, I don't know what it is. And there is differentiation here. And I don't know how far this differentiation is allowed to go. And the whole point is you're saying that North Carolina, has a sovereign interest in this and that, and that's fine. What you don't have a sovereign interest in is discriminating or differentiating between in-state and out-of-state businesses. But you do, and nobody, I want to make the point clear, nobody is saying that you have to give up your interest in not allowing out-of-state retailers to ship directly to consumers. Nobody, you can have that prohibition on the books. Nobody's saying you can't.
So if I may, I'd like to try to one more time to convince you that the discrimination that Your Honor has identified is not cognizable under the 21st Amendment. And I think it's helpful to look at the North Dakota decision from the Supreme Court, And what the court said there is that, if you look at a specific provision that might appear discriminatory, if you take a broader lens, you'll see that there's no discrimination at all. And really, shipping is just a byproduct of allowing in-state retailers to make sales. And that's our fundamental point, that is not discrimination, because it's just a way of delivering a lawful sale to a consumer. And so I think and the reason why that's a concern to North Carolina, to all states, is that if you start to make those distinctions between, all these aspects of the three-tier system are allowed for in-state retailers, in-state interests, and not allowed for out-of-state interests, then that's going to start chipping away at a whole host of provisions that are, simply an adjunct to the three-tier system. So I just fundamentally push back on the idea that shipping is the correct frame in which to view the issue.
Well, it's a question of how the shipping is done. Nobody's saying that the three-tier system would just normally have the shipping go through the wholesaler, which is an integral part of the three-tier system. There are lots of states that don't have this carved out for in-state retailers. There are many states that don't accord this kind of preferential treatment.
Well, I think I would just say in response that there are 24 states that allow for in-state retailers to make these kinds of shipments, and don't allow out-of-state retailers. And so what B21 is asking for.
But there are a whole lot that treat them on even terms.
I think that is, I guess, if I could sum up, I think that that is the state's sovereign authority under the 21st Amendment to adjust the details of its regulatory system for alcohol.
All right, we thank you.
Ask questions, Judge.
Yeah, absolutely.
North Carolina's primary interest here, or at least that espouses publicly, public safety and revenue.
Yes, Your Honor. So I would say the primary interests are public health and safety, and there's a lot of various
public
subcategories.
Health and safety. I said public safety. Yes. Public health and safety, and that's the primary interest.
That's correct.
Secondarily, revenue.
That's correct.
That's everything. Everything that you do is tied to those interests.
Well, there are other
context of regulating liquor.
I think there are other interests in terms of preventing access to minors and to just having.
Part of the public. That's part of the public safety and interest.
I think that's correct.
Well, I would include that in underage sales.
Yes, Your Honor. And if I may, I just would like to point out
consumption, all that stuff.
That's right.
But anyway, is that what North Carolina espouses that it's doing?
That's our primary interest. And I think what I would say is to take a step back. Of course, it's the state in making all its regulatory decisions on alcohol is trying to balance competing interests. So we're trying to balance the interests in the vast majority of consumers who are ordinary drinkers and can responsibly drink in moderation, and this narrow subset, problem drinkers, binge drinkers, and alcohol-dependent drinkers, who create a really, a scary level of social harm. So I would just like to make one example. There is an Illinois tax, this is at page 289, 290 of the record, that it was a pretty modest tax increase. And, academic studies have shown, government analyses have shown that this minor tax reduced the overall statewide traffic fatality rate by 26%, and that it decreased the prevalence of certain sexually transmitted diseases by 21% to 11%.
All right, but wouldn't your interest in promoting responsible drinking be furthered rather than curtailed by requiring in-state retailers to go through the state's three-tiered system and the wholesalers and everything? If what you're interested in doing is promoting responsible drinking, then bring the in-state retailers within the aegis of the three-tiered system.
Well, I think, Your Honor, what that exposes is that these are fundamentally policymaking decisions, because you're balancing competing interests. I mean, North Carolina, the winery exception, for example, is a niche market of wine enthusiasts who want a greater selection of wines than the 90,000 that are available from North Carolina retailers. And
It's always easy to balance the interest by differentiating against an out-of-state business. I mean, that's an easy balance. We'll let it, and that's what the Commerce Clause is designed to prevent, a balancing of interest that favors in-state concerns.
I'll just make one point in response to that.
It's too easy to do. It's too easy to do, and the problems under the Commerce Clause with surrendering to parochialism. That's what concerns me.
I think that the in-state, out-of-state terminology is a little bit misleading. I mean,
No, it's not misleading at all. That's the way the law is framed.
well, most of the, I guess from a practical standpoint, most of the largest wine retailers, alcohol retailers in North Carolina, are out-of-state businesses. Harris Teeter, Target, Walmart, Total Wine. All they have to do is comply with North Carolina's three-tier system, and then they're considered an in-state retailer. So B21 wines, if they would like to comply with our three-tier system, they have full and equal access to the North Carolina market.
Thank you very much, sir. We appreciate it.
Thank you.
Mr. Tanford.
Thank you very much, Your Honor. A couple of minor points. One is that earlier on it was mentioned that is in the record there are 400,000 out-of-state retailers. If you look deeper in the record, it shows that in states that actually license, we're not suggesting that they should allow every shipping without license and without joining their regulatory system. These are out-of-state retailers. The plaintiff wants a license, but North Carolina won't give them one. They're willing to comply with regulations. They're willing to comply with exactly the same regulations about age verification and remitting taxes as out-of-state wineries do. Their argument about that there's a public safety and tax danger from out-of-state shipping is belied by the fact that they allow out-of-state wineries to do so, and they manage to collect taxes and protect their public safety. We are not asking for unlicensed and unregulated willy-nilly shipping. I agree, that would be a real problem.
I think that's a fair comment. Is if they're if you're going to rely on the three-tier system, do it, but do it consistently. And once you've kind of made an exception for wineries, do you still get the benefit? I don't know that we got a appellate case that really addresses that point.
I think I recognize here that the difficulty of balancing these two provisions, you mentioned there are 24 states or something that are now in this process. There are about 10 of those that are now in litigation. Exactly, because this is really a new area.
The question I have is, in the absence of a Supreme Court case that deals with that, the North Carolina's position is, we do. They're not ignoring that. They're just saying that's such a small sliver that we have the sovereign prerogative to do that and still maintain our interest. And so, I think our question, or a question, is whether, if you've kind of made an exception to the three-tier system, do you give up all your benefits of it? Or do you say, look, the 21st Amendment's a pretty unique animal. As Judge King said, it's the only amendment that deals with a specific product like this. And it seems it just is unique. And is that something that we really have the benefit to come in and second guess North Carolina for carving out a little exception?
Well, the Supreme Court has said yes. The Supreme Court, in absence of specific precedent, seems to me you fall back to general constitutional principles. Principle number one is, if you look at the way that they talk about the 21st Amendment, both Granholm and Tennessee Wine, the Supreme Court is clear that the 21st Amendment did not constitutionalize the three-tier system because the three-tier system didn't exist. It constitutionalized the law prior to Prohibition, and that law prior to Prohibition contained a provision in Supreme Court cases in the Webb-Kenyon Act, not the one that preceded the Webb-Kenyon Act, that said the limits of a state's authority. is with discrimination against interstate commerce. So that notion of that the boundary of the state's power to regulate its three-tier system is discrimination unless they can prove that discrimination is necessary or reasonable because there is no reasonable alternative. North Carolina admits there's a reasonable alternative. They allow out-of-state wineries to bypass their three-tier system and sell directly to consumers as long as they get a permit, remit taxes, comply with a set of regulations about labeling and reporting to the state. And so there is a reasonable alternative. And every single prior case has said there must be some evidence that the alternative will not work. It's working in other states. There's evidence, extensive evidence in the record that the states that allow direct shipping do not, in fact, experience any increase in consumption, in part because we're talking about wine and not, as in the Illinois case, a tax on liquor, on spirits.
But that's an empirical question as to whether there's an increase in irresponsible drinking or what have you. And I would think that's a matter of legislative competence. And I don't feel competent to talk about what the actual effects on drinking are of a ban on out-of-state allowing out-of-state sales, retailers to sell directly to consumers. It seems to me, and this is where I part company with your position, it seems to me that the 21st Amendment requires, and the three-tier system requires, that we respect the state's choice of remedy. And they've laid it out for us. They've said, they've said this, they said just bar, the remedy is to bar in-state retailers from shipping directly to consumers. And there's a good deal to be said by simply vindicating the state's empirical judgments.
Go ahead. I fundamentally,
quickly, because your time is expired.
If I can just address, I disagree that the legislature has said anything yet about which remedy it prefers. Their severance provision says sever the unconstitutional part. It doesn't say.
Well, they have, because they have a severance. The legislature has a severance provision that's in that statute, and the Attorney General has represented to us that the severance provision would allow, if he was forced to it, would allow barring in-state retailers from shipping directly to consumers is infinitely preferable than to open such shipments to out-of-state retailers. So we have enough here. But at any rate, Counsel, we've appreciated your argument, and we appreciated the opposing arguments. If Judge King or Judge Quattlebaum has any further questions for you, I'm happy to let them answer it. Judge King, do you have anything further you wish to question Mr. Tanford about?
No, Your Honor, I do not.
Judge Quattlebaum?
No, I don't. Thanks, counsel. I appreciate the arguments.
Thank you.
Thank you both for your arguments. We appreciate both of them a great deal. And we will adjourn court and conference the cases.
This one is adjourned, guys.